It's the state of Florida versus Florida. Case number 12CA, or CF, I'm sorry, 1083. Mr. Potts wanted to appear by phone, so should we take that one up first?
It's fine with the state, right?
Yes, sir.
Okay, I have his phone number here. I'm working with him on the line. Good morning.
Good morning.
Mr. Ponce?
Yes, ma'am.
Oh, hi, this is Judge Nelson. We're all here in the courtroom, and we decided that we would go ahead and take the motion that you wanted to appear on first. This is the motion regarding confidentiality of witnesses. And everybody appears to be here in the courtroom. Mr. O'Mara, it's your motion.
Thank you, Your Honor. And I don't know if the court has seen the notice of appearance filed, I think, this morning by Mr. Nielsen.
No, I have not.
Okay.
Morning, Your Honor.
Okay, Mr. Nielsen, you open appearance of record for the anonymous witness?
Yes, ma'am. There's three that I'm here to represent their interests, and they are anonymous at this time. Okay, thank you, Your Honor.
Thank you. Your Honor, as background, there was some correspondence forwarded by one of the witnesses, and as referenced in the motion, a very significant witness, in that that witness is actually an eyewitness to the altercation. So that was his testimony, and his full, complete, and unbiased testimony is going to be very, very relevant in the case. We have in place, and we normally have in place, good security and ways to handle witnesses. And when you come before an open court, you come before an open court. The concern, I'm not going to belabor the point that you know I've said many, many times in different contexts, most particularly in context of the motion for maintaining the anonymity of the jury. It's just that this now seems to have spilled over to the witnesses themselves. Again, as mentioned in the anonymous jury argument, it is normally, and it is appropriately, the defendant's right to proper and full confrontation of witnesses. I don't believe that that confrontation applies under the Sixth Amendment to anybody else but a criminal defendant, and to the extent necessary to assure that the witnesses are willing to testify properly without concern for ridicule, retribution, or whatever else it might be that may come out of the result of this trial, that Mr. Zimmerman affirmatively waives that right and suggests that a procedure that this very courthouse, Judge McIntosh in the Hathaway case, similar in that there was a witness that had great concerns about maintaining anonymity, and in that case, the process or procedure was put in place where that witness would be available for review of the parties, but not of the general public and not of the media. There are many cases that address the court's certain discretion to address these issues and to properly resolve them. Since, of course, that happened, then there are now two other witnesses who have evidenced a similar concern. If I may, knowing the case as I do, I think that there are a very few number of witnesses who would be in this category. I, of course, hesitate, and I will not reach out to others to ask because I think that's very problematic. But I think that the parties would probably agree, if we had an opportunity to do so in camera or literally at the bench, that there are, in addition to the three identified, maybe 3 or 4 others who fit this category. And the category is that they are not known yet and have not put themselves out in public. That was a threshold requirement that Judge Lester put in. If you talk to the media, you're not protected. They meet that criteria. They meet the criteria as well as they're going to have testimony that is going to have impact on the jury's decision. And I mean by that, they're not just records custodians or incidental witnesses. These are witnesses who have relevant, substantial testimony to offer to the jury. And at least 3 out of these 6, well, actually another one that we know of because of the person's statements in deposition, have concerns, do not want to be involved in the case, and want their anonymity protected. So while I am sensitive to the caution that the court has to have that we need to keep control and not simply let an unwarranted concern rule the way the trial is held, on the other hand, if there are warranted concerns, if they're limited in number, and if we can put a procedure in place such as a screen literally in front of the witness so that the parties would have access but not the media or the public, then I think we've accomplished what we really should. Not to jump up on a podium soapbox as I on occasion do, we really need to make sure that not only that my client gets a fair trial, but also that the process itself is protected greatly, particularly with a review that this case is under from the public. And I think in this way, protecting the nuances of the witnesses as best we can will still guarantee a fair trial, though it is a restriction on the media's right, and I understand that. And therefore on the public's right to a certain extent, if you really, I would suggest, if you do a balancing of protecting my client's right to a fair trial, the process is right to make sure that these witnesses don't come before the jury and hesitate, limit, or in any form or fashion believe because of the retribution or whatever may happen to them in the future, impact on their testimony other than being full, complete testimony, then we've really affected the process. And
I understand your argument, and to keep it, we have a lot of people who probably want to talk about it. But,
I understand, Your Honor, but again, realizing that it's my client's right above and beyond everybody else, including the media, I want to make sure that his position is fully thought out, that we have nothing but full and complete testimony from these witnesses.
I appreciate that. Thank you. Mr. Mason,
Judge, I would like to just add a little bit, if I could, Your Honor. I move on behalf of my clients to adopt the written motion filed by Mr. O'Mara as well as his arguments. And we do want to make sure it's clear to the court that the witnesses do want to participate. It's not that they don't want to. And they have, as recently as I understand it, yesterday, met with the state attorney's office. The problem is, of course, what Mr. O'Mara's outlined, the safety, privacy, and other issues. And, obviously, we believe that between now and the time of their testimony, there could be some type of procedure that both sides could agree on that would provide the results that Mr. O'Mara's outlined for his client, as well as the witnesses that I'm here to represent. And, Your Honor, I didn't know if at some point, if you wanted me to approach, I would perhaps like to name them under seal, just so the record's clear as to exactly who I'm here on behalf of.
Okay, did you already indicate that to the state?
I did, Your Honor.
Okay, and at some time if you want to put it in writing and hand it up to me and I'll know who you're talking about.
Okay. All right, Your Honor. All right. Thank you very much.
Ms. Fugate, would you like to be heard?
Yes, Your Honor. Thank you, Your Honor. I'm here on behalf of the Orlando Sentinel today, and I apologize for not filing a formal brief, but the motion was under seal, so until I got here today, I wasn't exactly sure the relief or the procedures that the defense was requesting, and still don't quite know my client's position on all of these because this is really the first that we knew of precisely what they were asking for to maintain these witnesses' anonymity. But a basic proposition in our courts is that it's not a private proceeding, it's public property. And what goes on in a courtroom is open to the public, and it is the public's property. Witnesses don't get to come to court and testify anonymously unless there are very compelling reasons for a witness to do so. Sometimes restrictions on a ban on photography of a specific witness if there's a juvenile and it's a sexual assault, or if there's an overriding interest. And I think Your Honor is now very familiar with the post-Newsweek standard on when you can limit photography. And you have to show that there would be a qualitatively different effect on that particular witness that would be separate from other witnesses in the case. And I think it's a bit troubling, the notion that the parties could simply agree on measures that would trump and restrict the public's right of access to these proceedings and to know the evidence and the witnesses that are testifying. It's a public proceeding. The parties can't simply agree to cut off that public access. There are very high standards for doing that, and I don't think they've been met in this case. If it's to ban photography or limit photography in the courtroom, it has to be the post-Newsweek standard. If we're talking about closing proceedings, it's the standard of Miami Herald Publishing Company versus Lewis. I don't think that any of those standards have been met. It's not simply a balancing of fair trial rights. In the Lewis standard, it's that that the defendant could not receive a fair trial, despite all these other alternatives. I don't think that's been met. I'm not sure if the defense is actually asking for the courtroom to be closed or simply restrictions on photography. But even the restrictions on photography has an evidentiary standard that has to be met. I don't think that's been met. I haven't heard anything today that's been met. I can understand why some witnesses may want to remain anonymous, but when you come to a case like this, that simply isn't their choice. This is a very high-profile case, and in these cases, especially with crucial witnesses, transparency is all the more important. In the post-Newsweek case, the Florida Supreme Court went on at great lengths about how transparency enhances the judicial process. It enhances and aids honesty. If a witness is going to get up there, they might be more reluctant to lie on the stand if they know that people will know who they are. That you can go and check that. Transparency generally, it's not a detriment to the process, it aids the process. And I think this flips it on its head and assumes that knowing these people's identity is going to be a detriment and hinder these people from testifying.
I understand your argument.
Okay. And Your Honor, if you could, we certainly would appreciate the opportunity to submit some case law to you in any briefing now that we know specifically what the defense is requesting. But I think it's essentially the post-Newsweek standard that you're now familiar with after the last case. But if you would like some additional briefing, we'd be happy to do that.
Thank you very much.
Thank you.
Mr. Ponce, do you have anything you would like to add to the argument?
Yes, and not a lot, Your Honor. I want to read what the Florida Supreme Court wrote in State versus Green, which is reported at 395 Southern 2nd 532, because it speaks to exactly what we're talking about here. And I quote, "We realize that courtrooms are intimidating and that apprehension accompanies most individuals who must participate in a court proceeding. This, however, is not a product of electronic media's presence. Courtrooms were intimidating long before the advent of electronic media. Trials with considerable public interest have always resulted in courtrooms full of spectators, news reporters, and sketch artists, all of whom add to the intimidation of the courtroom atmosphere. In our view, the single addition of the camera in the courtroom in these circumstances should not increase tension significantly, given the fact that the electronic media will report the proceedings whether or not the camera is actually in the courtroom." Your Honor, I've looked and I've not found any decision anywhere saying that you can put a screen or some other physical barrier in a courtroom to obscure a witness from view. And I've looked and I've not found any.
Well,
The Florida Supreme, yes, Your Honor.
I just wanted to tell you, because Mr. O'Mara had mentioned the State versus Hathaway case that happened here in this courthouse. There was a motion, the witness was protected in the Federal Witness Security Program. The director of the United States Marshal Service came in, and there was a hearing conducted on the state's motion to keep the identity confidential. And the Supreme Court pointed out in the case of Waller, W-A-L-L-E-R versus Georgia, and that's at 467 U.S. 39, 1984 case, that set forth the test that was to be used in order to protect the government's interest in inhibiting disclosure of sensitive information. And it's after that hearing on that test that the motion was granted for that particular witness only. Go ahead, I didn't mean to.
No, that's perfect. That actually segues to 2 places I wanted to take you to. The first is that, as Your Honor said, and the Florida Supreme Court has said this in Chavez, even where we're just talking about not photographing a trial participant, in this case a witness, there has to be an evidentiary hearing. And Your Honor has mentioned in the Waller case, I lost the title, but the head of the service came in to talk about the government's interest in maintaining the anonymity of that particular witness. And we don't have that here. As Ms. Duque said, there's been no proper evidence of how media coverage or electronic media coverage of this witness will be different than anyone else who might have to come to this courtroom. And the second point Your Honor made, and it's highlighted in Waller, is that the Florida Supreme Court in the post-Newsweek decisions that Mr. O'Mara mentioned, set out categories of witnesses who are among the type who might be eligible for an order saying that you can't photograph them. And the categories that they set out, and again, the court says this isn't an exhaustive list, but it's illustrative. The list includes prisoners, confidential informants, child witnesses, sexual battery victims, witnesses under protection of a witness-type relocation program. We don't have that here. We don't have that here. I don't know if regular or normal is the right word, but we don't, as Mr. Duque said, we don't allow witnesses anonymity. We don't do secret witnesses in this country. That's not what we've allowed. So, Your Honor, I don't believe that there's any basis for Your Honor to enter an order saying that this witness, certainly not on the record before you, that this witness can't be photographed, that some screen should be put up on the Hadaway case. I don't know who that witness was. I don't know what they argued. I don't know whether an appellate court approved it. I don't know anything about the Hadaway case. But I don't think on the record before you there's any basis for the entry of an order putting up a screen. I don't think there's any basis for the entry of an order barring photography of this witness. And I don't think there was mention about to what extent, if the parties don't want to mention the witness's name in open court, I mean, that's their prerogative. No one can compel them to talk about that. But I just don't believe there's a basis for the relief that Mr. O'Mara is seeking on the record before you. And that's all I have, Your Honor.
Okay, thank you. Mr. De La Ronda? Mr. Guy?
Good morning, Your Honor. Judge, we would ask that you deny the defendant's motion. We are all appreciate and understand the scrutiny that this case has drawn. However, we have gone to great measures, as the court knows, to protect the privacy of these witnesses. The state's concern is this: what is the jury to think if we were to mask or erect a screen up for a particular witness? That would, to me, would be alarming and confusing to a juror and might otherwise highlight their testimony when it shouldn't be highlighted. Also, I think, as we've discussed before, that the very content of their testimony, I think, would reveal in some respect their identity, for example, their address or their perspective from their residence of the events of that evening. So for that reason, we would ask the court to deny the motion. Also, we do not concede that these three persons referenced are critical witnesses. We believe every witness we're going to call is critical. So again, it unnaturally highlights the testimony of that witness, which we feel like would prejudice the jury and also may limit the state from inquiring of the witness about their perspective to the events that evening. So for those reasons, we'd ask you to deny the motion.
Just very briefly, before the court makes the final decision, I think in order to understand the gravity that the witnesses place on this concern, that you hold an in-camera hearing outside the presence of the media to maintain their anonymity to the extent of allowing them to testify truthfully to you what their concerns are, because though they're represented by counsel, I think that we need to give a three-dimension to their concerns before.
Their concerns fall into one of the categories as set forth in the case law?
You want me to give you my understanding of their concerns?
You said it for hearing today.
Okay, I'll give you my understanding. My understanding is that they are very concerned that then when they come before the court and they testify truthfully as to what they saw, and if it leads to a certain verdict, let's say an acquittal, that they will be subject to ridicule or retribution because this case is already identified and has brought out an enormous amount of anger on both sides of the situation, and that these witnesses have said they are very concerned to the extent of possibly having to move out of their residence, with what might happen if they come before this court and give information that leads towards an acquittal. Those are concerns that have been referenced. And though that's not in the Times matter yet, I'm not sure that we've dealt with many Zimmerman cases in our history yet, particularly not one that brings out so much animosity on a social issue and focuses it on a trial where an acquittal has suggested to be a loss for civil rights and a conviction something else. So their legitimate concerns are their personal concerns for their safety when they do what they're being required to do as a citizen witness, and that they're going to have an aftermath that they have to deal with, and we have an easy way to minimize it. Is it perfect? No. Does it evidence a sensitivity by this system to witnesses who have to give testimony under oath? Yes. So the balancing test, I think, should weigh in favor of those witnesses maintaining anonymity. Again, it's Mr. Zimmerman's right more than the media's right. So all I'm asking is to have an opportunity at this point for the witnesses to come before you in camera, and so that the court can question their concerns and see if they're in fact legitimate, because I think you may find that they are.
Judge, I would just join in and ask that you reserve your ruling until you did have an opportunity to hear from the witnesses. And I think Mr. O'Mara made a great point that this is basically a case of first impression in regards to the totality of it, and perhaps there will be another category added to that list. So that's what I would ask.
At this time, the motion is denied. Is there any other reason, Mr. Pons, that you want to participate in this here and the rest of the hearings?
No, ma'am. If there are no other media-related or access-related issues that are going to come up, I don't need to stay on.
Are there any other issues? I don't believe there are.
Just one, Your Honor, as to the names being released, that's still going to be under seal at this point?
It's under seal until we start the trial.
All right. Thank you, Your Honor.
Okay, thank you. Thank you.
To that point, Your Honor, real quickly, under seal, the only thing under seal was the public records were held exempt.
Right.
I'm not sure if that's what counsel meant.
I think that Councilman is under the prior court order.
Yes, ma'am.
That had them listed by a witness number that will remain in effect until the start of the trial.
Okay, thank you, Your Honor.
Okay, thank you.
Judge,
You're welcome.
just for clarification, did you want me to file a separate pleading under seal, or did you want me to literally give the names to the clerk on just a written piece of paper?
You could give the names to me on a written piece of
Okay.
paper.
All right, I'll do that right now, Your Honor.
Okay, thank you. All right.
Thank you, Your Honor.
Thank you. Okay, bye. Thank you, Ms. Speaker.